Okay, welcome everyone. Thank you for coming today. You're compelled to be here, of course, but it is a summer Wednesday and you decided to come in for Medicare as secondary payer training. I know this is compulsory, but I can also look just the excitement in this room. When I said Medicare secondary payer, I just see the ripples of interest that this is going to generate. So this is not a fun subject. This is pure compliance work, but it's something we have to get right, and we have to get it right for our clients. So that's why we go over it. It's also one of the trickier areas in workers' compensation because this can sometimes slow down our settlement of our cases. This is where people kind of get a little lost sometimes, and those settlements kind of fall off the rails. And so this is something that we want to be on top of, aware of, and do a good job of. There have been some changes in the last couple of weeks. So there's a handout which has all the changes from the new reference guide, which I'll talk about in a little bit. All right, so thanks for coming in for this exciting topic. This presentation is not legal advice. I'm not your lawyer. This is for CLE. Attorneys in this room, you've all signed in, I hope by now. Everybody at home, we're taking electronic attendance for everybody who's going to be here. Now, this slide says, put away things that buzz or make noise. Okay, but also this topic is one where I think people do have questions about. So as I'm going through the presentation, if you just want to yell out a question that's good, feel free to do it, okay? I would love for this to be interactive in any way possible. So if you have a question about Medicare, even one about your own case, just don't say anything about the case because there are clients listening, meaning anything identifiable. I would love to answer your question, all right? After the presentation, we have to sign out, yada, yada, yada. You've done this a million times. All right. Medicare as secondary payer. Why am I standing in front of you right now? What is Medicare? Well, we all know that we pay Social Security tax. You pay 13% Social Security tax on yourself. I pay 13% Social Security tax on you. Where does it go to the federal government? What do? They spend it on these programs, and the Medicare program, as you know, is running out of money. The law says that workers' compensation programs are not supposed to shift the burden of medical treatment onto Medicare. That law was on the books since the early 80s. I think 1981, 42 USC 1395Y was modified to say us workers' comp carriers in particular are not supposed to screw over the federal government and shift the cost of Medicare, of medical treatment into Medicare. Okay, we were not supposed to do that. Now, I will admit, I did that. Okay, and anyone who's practiced for a long period of time did that because up until the late 90s, early 2000s, we would go and settle a case under Section 32 or in New Jersey under Section 20. And the claimant would say, I'm getting $100,000, it's awesome, but I need to get more medical care in the future. Who's going to pay for that? And what would we say to the claimant back then? Well, just charge it to Medicare. You're on Medicare, right? Just charge it to them. Okay, that was inappropriate. It was wrong. But Medicare never enforced this rule that says we're not allowed to do that. And then in 2002, they came out with a memo that said, you guys have to stop doing this. Why did they come out with a memo in 2002 and suddenly start enforcing this law that had been on the books for a long time? They were running out of money, right? They were like, we're running a deficit. We don't have money to pay for it. So they started to say to themselves, wait a second, all of these workers' comp settlements, these motor vehicle accident settlements, they're pushing the cost of medical onto us. We're going to run out of money. Okay, so that's when this started to really take root. And the federal government really wants to make sure that they're not getting our costs thrown over to them. I don't know. I'm changing slides over here. They're just not changing over there. I don't know what the deal is. So they could just listen. So what is the Secondary Payer Act? It's supposed to protect the federal government from bad behavior on the part of workers' comp insurers, motor vehicle accident insurers, any insurers that are going to shift the costs from themselves onto the federal government. So you should always be thinking, you're acting like the federal government's attorney when you're protecting their interest, right? That's our job. We have obligations that I'm going to talk about, and there are some bad penalties about this. The last thing I want to stress, I'm going to keep stressing this during this presentation. There's a huge difference between our obligation under the law, what we have to do representing an employer or carrier, and what the federal government's going to do. they're not going to review every single one of our Section 32 settlements in New York or Section 20s in New Jersey. But that doesn't mean that we don't have an obligation to take care of their interests. And this is the chief place where attorneys get lost and get in trouble, because they believe or they act like the federal government's workload review threshold is a safe harbor, which it is not. Okay, it is not a safe harbor. So I'll talk about that in a second. All right, slides are not working for home players, right? Do you want me to like stop sharing and try over again? Yeah. I'll stop sharing. So I've stopped sharing now. Try sharing again. Pick my screen. Okay, it's working. When in doubt, turn it off. There we go. You got it. We got it. All right. Great team. All right. Let's try to get back on track here. So now this guy popped up over here. How do I get over it? Okay. All right, 42 U.S.C. 1395Y. It's long. I read it so you don't have to. It just says we cannot shift our responsibility to pay for ongoing medical onto the federal government. Okay, we're here to protect them. Essentially, we have to do the federal government's work for them, and I don't get to send them a bill, and you don't get to send them a bill, because we simply have to make sure that our clients comply with this rule. All right. Now I'm clicking and it just doesn't, I got nothing here. Okay. All right. Now, the word secondary means something here. It's called the Medicare as Secondary Payer Act. Should be a hint. We, as the workers' compensation carrier or employer, we're always primary to Medicare. And in fact, we're primary to all other payment sources. For example, if a workers' compensation entitled claimant goes to the hospital and presents their Medicare card for treatment, and that treatment should have been paid for by workers' compensation, we're primary to them. What if someone presents their Blue Cross Blue Shield or their private health insurance card at the hospital for treatment? Again, that should be a secondary payer. Workers' comp is always primary. Okay, so that's just a general rule. It applies in context of all other sources of funding for medical treatment for a claimant. Already said that part, skip that. Okay. Now, the compliance is important. So it's not just we're trying to be nice and make sure that the federal government doesn't run out of money. There's an opportunity for them to get a recovery against our client directly for any amount of money that the federal government spent that should have been spent by the workers' compensation carrier, all the way up to the complete cost of whatever you, or the complete amount that you put in your original Section 32 settlement. So if you do a Section 32 settlement for $100,000, and then the claimant goes and charges $100,000 worth of care to the federal government that they were not supposed to, the federal government can come back against us and say, guess what? Bad news. You still owe us the $100,000. Now they're going to go to the claimant first. What's the claimant done with their $100,000, guys? They got a Section 32. They bought a boat, they bought a car, they went to Atlantic City, they gambled it away, it's gone, okay? The law says that they can subrogate against any party to the settlement, which includes us. So really, they're gonna come after our client, okay? Also, interestingly, it doesn't protect the judge. It's any party, anybody who was there at the time of settlement. So it could be the attorneys, right? They could be a party to a settlement. It's a little bit scary. Okay, so they can come after us for that. If the government says, hey, we paid money for medical care, now we want you to pay us back, they get to charge interest on those conditional payments, or what they paid conditionally, okay, the pay and chase portion of the collection. And then they can refer you to the Department of Justice, who's allowed to go after you and file a summary action against that alleged person who owes, and that, again, would be the carrier. If you don't comply with that immediately, the penalty is double. So if you do a $100,000 workers' comp settlement, the claimant embezzles the money, spends it on junk, doesn't put any of the money aside for medical care, then goes and charges $100,000 in medical to Medicare, Medicare can ultimately come after our client for double that entire settlement. Not nice. Statute of limitations, 5 years. There's another aspect to this, which is just as dangerous, which is purely our client's risk, which is under Section 111 of the MMSEA Act. Our clients have to report every workers' compensation settlement to the federal government so they can match, so they can figure out, hey, were we supposed to protect the federal government's interest? If they fail to report a claim, they can get a fine of up to $357 a day, up to $365,000, and that's per claim. So that's a scary situation. Most self-insured employers and carriers are using vendors to make sure that they are in compliance with their federal government reporting of these settlements. What kind of cases do we care about, or should we be thoughtful about? Any case where the claimant has a Medicare entitlement. Now, the dangerous thing here is sometimes the claimants don't even know they have a Medicare entitlement. During the enrollment periods, like in January on TV, you see all those ads about Medicare Advantage plans, because there's all these private health insurers that have now gotten into the business of administering people's Medicare plans. So you can get a Blue Cross Blue Shield Medicare Advantage plan. It's called a Part C plan. So the scary thing is sometimes claimants don't even think they have Medicare, because when they pull out their insurance card, it says Oxford Insurance on it. It says Blue Cross Blue Shield, it says Aetna on it, and they don't even realize they're on Medicare. So they might not know they're entitled to, but if they are entitled to or on a Medicare plan, that's a concern for us. And any case where you're going to do a full and final settlement where we're not going to have to pay for future medical. So those are the big triggers. Those are the two things that I want you to be mindful about. Now, not everybody is entitled to Medicare, so we have to be thoughtful about that. Now, Medicare also will go and to start paying in your workers' comp case. Person is presenting their Medicare card. Maybe they're not doing it nefariously. Maybe they're just doing it out of habit. They just think every time I go to the doctor, I present my Medicare card, and I'm not thinking, oh, by the way, I'm at this doctor for a workers' compensation situation, so I shouldn't be presenting my Medicare card. When that happens and Medicare pays for treatment while our workers' comp case is pending, so we haven't settled the case yet, Medicare will just go and pay those bills. But they say that they're paying them conditionally, conditioned on us paying them back. Okay? Those things are called conditional payment cases. Come on. All right. And then there are other cases, like when you settle a case under Section 32, you've given this person $100,000. That's for their lost time benefits that maybe would be due and owing. That's for any permanent residual disability, and that's for any future medical. Well, we've now foreclosed any future medical. We've foreclosed our obligation for or responsibility for future medical. Now we've got to take Medicare's interest into account if they're Medicare entitled. Okay. What kind of claims are impacted? What should you be thinking about when you think about the claimants that you're going to be dealing with? Well, you can't be entitled to Medicare unless you're over 65 years old. So that's your case population, your claim population. Why is that bad? That's generally your hardest, usually longest lasting cases with the claimant who's not motivated to return to work, right? So those are some of your problem cases where the person's a little bit older. Also, any claimant who's already on Social Security disability might become entitled to Medicare health benefit as well. So Social Security disability is basically a federal disability program. After you've been deemed totally disabled by the Social Security Administration, after 2 years of total disability, your medical is then covered by Medicare. Okay, the presumption there is you're permanently and totally disabled. You're not going to be getting any more, you're never going to ever work again. After 2 years, you're now entitled to Medicare. So that could be a claimant who's 25 years old, who's very significantly disabled, and now is entitled to Medicare. So it's not just people over the age of 65. The other problem with this is people can apply, they can have a workers' compensation case, and while that workers' compensation case is pending, apply for federal Social Security disability. Say I'm permanently and totally disabled. Two different standards. Social Security disability is a lot easier to obtain than workers' compensation awards for the same permanent injury. Okay, it's a lot easier to obtain the federal award. And also those federal awards can go back in time. So the person can apply for a Social Security disability award, be denied, go through an appeal process, and then 3 years later, the Social Security Administration says, yeah, you know what, you are permanently and totally disabled as of 3 years ago. So that's scary for us because we could be defending our workers' compensation case. We don't know what's happening in that Social Security action, and then that person could be almost instantly entitled to Medicare benefits because they're going to go back in time and award that Social Security disability award. So that's something to be thoughtful about as well. How do we know the claimant's Medicare status? Well, sometimes our client will tell us. Remember, I told you under Section 111, they have to report to the federal government every workers' compensation claim, and every settlement absolutely needs to be reported. So they're doing a match on their side. And so a lot of clients will tell us when they refer a matter, this person's already Social Security entitled or they're already Medicare entitled. That's great. We also, in our office, we serve a demand in every single case at the time of intake on opposing counsel for the claimant to execute a Social Security affidavit. We open 4,000 cases a year, so we send out probably about 4,000 of those. I can probably count on two hands how many we've actually gotten back. We don't see a lot of people returning those and sending them back to us. But I serve it so I can protect our client. I can say, hey, at least we made the inquiry, right? That's prophylactic. Sometimes the claimant will admit to you, they say, hey, I do have Medicare, I am entitled. Oftentimes it's opposing counsel who will say to you, not only is the person entitled, but they're actually receiving Medicare benefits. And unfortunately, they tell us this once we've already begun settlement negotiations. Maybe we've already made the offer. Maybe we're already kind of down the road. We're reaching a number and then it's, oh, surprise, my claimant is on Social Security. So we've got to figure that out, okay? And then the other thought is you can look at the person's age and the amount of time they've been out of work and say, hey, maybe they're entitled. So the age would be, hey, they're over the age of 65, which means they might be entitled just by age alone. And then the other thing you might want to be looking at is they haven't worked in more than 2 years, which means they might be eligible or entitled to Social Security disability. And for those reasons, you might start to think, okay, this might be somewhere where we're going to have this type of problem, okay? But this is one of those areas where we're going to have to be proactive. We're going to look at our case and go, hey, is this going to potentially be an issue in our case? All right, so typical situation, claimant has a workers' compensation case against us. They're Medicare entitled as well. They go to the doctor and they should be charging it to us, the workers' compensation carrier, but by accident, they keep presenting their Medicare card, okay? I call that the type 1 case. That's the case where the Medicare has paid for care that should be related to the workers' compensation case. We'll contact Medicare. Our client will contact Medicare. We'll say, hey, we think this happened. We'll ask them for a conditional payment letter, which you've seen in your cases. It just looks like a payment ledger. It says, we paid this. You guys should have paid it. Here's how much you should pay us back. Okay, pretty straightforward. Now, most of our clients are actually very happy to reimburse Medicare for any of the treatment that's been paid for by Medicare, but should have been paid for by us. And the reason for that is Medicare pays significantly less for the exact same treatments than our clients do under New York's medical fee schedule. So it's actually a little bit to our advantage if the claimant shows up to the doctor and keeps getting their back rubs and their chiropractic massages and their vitamins and all the other nonsense they're up to paid for under Medicare, because they're going to pay significantly less than we're going to pay. And when they come back to us and say, I demand reimbursement, we're like, okay, sure. Okay. So that's how that works. Those are called conditional payments. Those conditional payment letters, we're still going to look through all those payments, make sure they're actually related to your case. Because the person could be going to the doctor and they're getting their back rub or whatever, but they could also be getting treatment for bronchitis or whatever other conditions they have. So look at those CPT codes, those ICD-9 codes, and make sure they match up to your workers' comp case. A little bit more challenging, and that's pretty straightforward, right? We're just paying back the government for something that we should have paid for. A little more challenging is protecting the future interest of the federal government and making sure that the claimant doesn't do something silly-hearted. So the type 2 case, and the one where I think we spend a little more of our time and attention on, is future interest. Again, the Secondary Payer Act says Medicare should never pay for something that should have been paid for by a workers' compensation carrier. And that includes future medical. So if you're closing out your workers' comp case and you're doing this because you have this future exposure, the medical component of that has got to take into account, wait a second, if I'm foreclosing my ongoing responsibility for medical, I have to make sure that there's no way, it's impossible for this to be shifted to the federal government. Okay. So we're protecting someone else's future interests. And again, it annoys me. Not that I'm a mercenary, but I like to get paid for my work. In this circumstance, remember, you're acting like the federal government's attorney. You're protecting their interest, balancing it against your own client's interest, of course, but no one's paying for us to do that. This is pure compliance work. This is avoiding a future problem for our client. Okay. So what's a future interest? You settle the case via Section 32. Our responsibility to pay for medical is ending. We need to think about who will pay for future medical. If the answer is potentially Medicare might have to pay for it, we've got to do something about it. We got to do something about it. Okay. So what are the things we can do? How do you protect a future interest? So early on, 20 plus years ago, one of the ideas was, well, we'll go out to the insurance market, and when we do a Section 32 settlement for $100,000 that forecloses our obligation to pay for future medical, we'll also go out to the market and we'll buy this person an insurance policy, a limited private health insurance policy that covers just this condition. Right? That would work, because then in the future, if they ever need any care, they just would present this other medical card and go get care under it. Now, the problem is the market didn't really support that, so that didn't work. So what came about, and there is, by the way, no correct answer to this, right? Answer to this. But what has developed over the last 20 or so years has been, you give the claimant a second envelope full of cash. Okay, you're going to get the one envelope, which is your workers' comp settlement. We're going to give them a second envelope. And we're going to say, here's extra, here's some more money. We're going to call this money that's set aside for future medical. And if you need future medical care, do not charge it to the federal government. Use this second envelope over here. Okay. Now, if you guys ever have like a rainy day fund and keep a little extra money in your sock drawer, that $100 that you always keep in your glove compartment in case you run out of gas in a dark place, anybody do those things? Don't you always rob yourself? And like that, next time you open that glove compartment, the money's not there, right? Okay. So the truth is, when we do that, when we put that second, give them that second envelope stuffed with $100 bills and say, here's your set aside. Can they embezzle it from themselves? Can they go and spend it on things? Can they go to Atlantic City and waste it all? The truth is yes. Okay. Now there are some things we can do to make sure that doesn't happen, but we really are just giving them two different buckets of money. And one of them we're saying, if you ever need care in the future, you're supposed to use this bucket. Now, Medicare publishes this reference guide, and it's very lengthy. It's very good. It's like 80 pages. I put a link to it in the materials that I handed out today. If you ever want to become an expert on this, read their book. It's very actually well written. It's very effective, but it's not binding on anyone, anywhere, anytime. Okay. The statute just simply says we, as workers' compensation carriers, we cannot shift our burden, our obligation onto the federal government. Now, the federal government has come up with all these crazy systems, the whole Center for Medicare Services. None of that's authorized by statute, and the reference guide is not precedent or binding, okay? But it exists, and it's useful. It's a good guideline. It's what most people follow. There are no, and it says this very clearly, I think it's on page 14 of their reference guide. Medicare does not have to review or agree with or bless or anoint any of these proposed set-asides, but in certain circumstances, they will, okay? And our clients like that. Most clients like that. They like the idea that we can come up with this set-aside program, a set-aside money for the claimant, a set-aside arrangement, and have the federal government in advance, before we even resolve the settlement, say, yes, my son, I do bless this second settlement that you have. And as long as nobody does anything that, sort of differs from the way you've explained the settlement, then we're gonna agree with you that you've protected our future interest. Okay. That's called a prior approval of the set-aside arrangement. And a lot of our clients like that because it feels to them like a warm blanket that they're going to wrap around themselves, and they're protected because they get this letter from the federal government, right? That says, hey, you did take our future interest into account. Thank you very much. If nothing changes, we're going to find this to be fair, just, and acceptable to us. All right. So they do that. But there is no requirement under the statute that says we have to do that. Okay, now I tell our clients, hey, if you don't want to do it, you don't have to. There are some downsides to going to the federal government and saying, hey, what do you think about this second envelope that I've put together here? What do you think of this arrangement that I've come up with? Because they could say what? It's not enough money. Put more money in. And that means our clients are going to have to come out of their own pocket and put more money into the settlement, right? So that's something that it's a bit of a risk that our clients have to consider. Now, a valid set-aside arrangement has to contain a few things. First, what do we think all the medical costs are going to be for the remainder of the claimant's life? The reference guide contains a method for how that's supposed to be figured out. And the method is frankly insane. The method essentially just says, how many years is this person going to live? And one of the innovations in the new reference guide is we're going to use the 2023 life tables, decennial life tables. So they've updated from the 2021s. And we're just going to apply that to whatever the medical treatment is the person's getting now. We're just going to kind of straight line that out over the rest of their life. And that's going to generate some pretty high potential medical valuations in these cases. You know, the rated ages that they use, they're now using rated ages from the updated tables. But again, these tables are actually, if you look at them, it says in the reference guide, we're using the general tables. So they're not using life tables that are broken down by by race or sex, right? So they're trying to be, I guess, simpler, but it's going to be a little bit less advantageous for us because it's not going to be as accurate as it potentially could be. Now, instead of putting just a pile of cash under the person's pillow in an envelope, we can choose to do other things. Okay, we can purchase an annuity. We can purchase a bundle of bonds. We can purchase financial instruments that would pay the person out that estimated amount of medical treatment on a yearly basis. So if the set aside comes back and says, hey, we have to put $100,000 over the lifetime of this claimant, and the claimant's remaining lifetime is considered to be 30 years. Instead of giving $100,000 right now, we'll give them $3,300 every year for the next 30 years, and that would be a prorated amount. Okay, so we can purchase, go to the market and get like an annuitization to make sure that we're not have to put out all the money at once. Okay, so that could be a little more efficient for our clients. Okay. We can also require that the set-aside amount, that envelope, is professionally administered, that the claimant doesn't actually have access to it, that someone else, it's a third party, it's going to be a vendor, is going to actually dole out the money to them. Okay, and the idea here is so that they don't embezzle the money from themselves and go to Atlantic City and buy that nice fishing boat that they're thinking about buying, and instead they actually preserve the money. We can also put into the agreement that any unused money, should the claimant pass away before they reach their rated age or their predicted lifespan, reverts back to us, the insurance carrier or the self-insured employer. Okay, I see a hand talking to the little guy, talking to the guy.
The fact that the money would revert, you're talking about in the annuity, correct?
In the annuity, yes. Right. Okay, because I think your question is really, and there's, you know, Section 32 approvals, the courts don't like any hold harmlesses. They don't like any rights of reverter in a Section 32. But really, we're not talking about the Section 32. Okay, that's that bucket of money or that envelope, that's going to them. They can spend on whatever they want. We're talking about the money that's being put aside only for the medical. We can get a right of reverter on that. Okay, I do think that's best practice. You know, in the bigger set-asides, it makes sense. Let's financialize them. Let's put them into an annuity. Let's look at lifetime value, and let's make sure we get a right of reverter in there. Now, opposing counsel is going to hate all of that, right? Because they want to get this second bucket of money and tell the claimant, hey, you're getting paid twice. Enjoy it, right? So that's going to be the conflict there. Now, the reference guide provides a method for how the government is going to say you should guess or estimate future medicals. I can promise you if you use a strict reference guide method, you're going to come up with a pretty high exposure or medical evaluation in these cases. I don't think that they're realistic. And obviously the government wants it that way, right? They want to really protect themselves, belt and suspenders, from the potential that every time ever in the future, they're going to have to open up their wallet, okay? But that's not required. Okay, so clients can choose to do an evidence-based, what's called an evidence-based set aside. So we're only going to put enough money in the envelope to cover medical treatment we think the person's really going to get. Right now, this person injured their shoulder, or there's an orthopedic injury. Just because they had 3 MRIs over the course of their treatment doesn't mean that every year they're going to have 3 MRIs, right? We know that at some point, they're not going to be doing radiographic testing over and over and over and over again, right? So an evidence-based, for example, set aside is generally going to be more efficient. And by more efficient, I mean it's going to be less, it's going to value the medical a little lower, okay? And there are some vendors out there, I mean, you could Google it, who say, hey, we've got the best valuation numbers. We're going to come up with a really good low figure for you, because their audience, their target market is insurance carriers who are trying to put as least amount of money into these set aside buckets as they possibly can. All right, when do we need to get set asides? Again, when they're entitled and when our resolution of our comp case is going to end our responsibility for future medical. But there's another time when we should get a set aside, and this is when you have a large workers' compensation settlement, which I'm going to define as over $250,000, and the claimant has a reasonable reasonable expectation that they're going to be entitled within the next 2 years. Okay, that's the other time when, hey, we got to be very thoughtful in those large workers' comp settlement cases where the claimant's about to be Medicare entitled, because there's a real potential there that we could really do something that is going to be clever and very maybe efficient for our client, but it's going to be not taking into account Medicare's potential obligation. And that's where you get really close to the line. So, all right, Greg, what does this mean? I get what when the settlement's over 250 and they're not currently on Medicare, but they're reasonably expected to be on Medicare. Greg, what does reasonable expectation mean? Well, it means that they're very close or about to meet one of the requirements for Medicare entitlement. Okay, so those entitlements are, well, they've applied for Social Security disability. Also, I will tell you this, in your workers' comp case, if you know the claimant has applied for Social Security disability, best practice, you should be getting a copy of that disability application, right? We want to see if they're applying for disability for the same things that is allegedly keeping them out of work in our workers' compensation case, right? So you should absolutely be following up on that. They've been denied Social Security disability benefits, but they are going to or have appealed it. The reason that's important is a majority of people who apply for Social Security disability get rejected the first time. Then they go to their friendly attorney at law who advertises during daytime TV. They file an appeal, and greater than 50% of the people who will file an appeal are ultimately granted Social Security disability. When you really start to dig into Social Security disability, you realize it's kind of like a federal welfare program, and you apply a few times and then you get entitled to it. The other time, now you're close to being a reasonable expectation of being entitled to Medicare. They're 62 and a half years old. You know, in 2.5 years, they're going to be entitled to Medicare. So if you're settling a case with somebody who's 62 and a half and you're settling it for more than $250,000 and you're foreclosing future medical, you have a reasonable expectation that there is a potential that Medicare is going to have to come in and pay. So we have to be thoughtful about that. And the last thing is the claimant already has end-stage renal disease, kidney failure. Why do I include that on the list? Because that's one of the enumerated qualifications for Social Security disability and Medicare benefits. All right. So I think everybody's with me so far. I haven't told you anything new. A couple little things here and there from the updates to the guidelines, but really this should be like, I've been a refresher. Okay. This should have been basically a refresher. All right. Now I want to get into the part where I lose people and we go off in the woods and there's scary things happen. Okay. Now we're going to talk about review thresholds, okay, workload thresholds. This has nothing to do with our actual obligation under the Secondary Payer Act. This is just Medicare has come forward and said, you know what, thanks guys for sending us all of these cases to review all your set-aside arrangements, but you're sending too many to us. We can't look at them all. That's what they've said. Okay, they said we just don't have enough manpower to review it. So Medicare has said, if you want us to review your case and bless it in advance and say your set-aside arrangement is good, it's golden, as long as nothing changes, we find this to be fair and just, and we're going to accept this. If you want that, if you want to opt into that process, and by the way, most of our clients do, then you've got these two workload thresholds that you have to get past. Okay, the first one is if the claimant is currently on Medicare, Medicare will only look at your proposed set aside if the workers' compensation settlement is over $25,000. What are they saying there? They're saying to you, we don't have the manpower to look at every little rinky-dink Section 32, rinky-dink Section 20 for $10,000, for $5,000, for $7,500, for $15,000. We just don't have the manpower to do it. So we will not review those. We won't send you that nice letter blessing or accepting your submission of your set-aside arrangement and telling you in advance that it's pre-approved. Okay, that's what they're saying. That does not mean that if you settle your case for under $25,000 and the claimant is Medicare entitled, that you don't have to get a set-aside or that you don't have a Medicare future obligation consideration to take into consideration yourself. Okay, it's just them saying we're not going to look at those. This is the number one thing that I see attorneys screwing up. Number one thing. I've had opposing counsel, and this is what it looks like. Okay, this is what it looks like. They send you an email and they say, Greg, can we do this one for $22,500? And if we do it now, that'll be really good because he's on Medicare, but if we do it for $22,500, we can get this done. And I'm like, okay, cool. We can do the settlement for $22,500, but we still have to take Medicare's interest into account. I still have to maybe create a set aside for this person to take care of any future obligations. Just because Medicare won't review it doesn't mean that's a safe harbor. And that's the confusion. Okay, I was once settling a bunch of cases, 4 cases at the same time with claimant's attorney. And I said, like, okay, we're going to do these all at, we're going to do separate settlements because they're separate dates of loss. And he's like, cool. What we're going to do is we're going to do 4 settlements for $24,999 each because that'll keep us under the review threshold. And I'm like, so what? That's cool, but I still have to take into account Medicare's interest just because they won't look at it. So when you hear those things from opposing counsel and they say, hey, we're going to do this one for $24,999, alarm bells should be ringing off in your head. Okay. And they should not, they think that it's a safe harbor, but it's not. Okay. Okay. The second review workload threshold is they won't look at cases where the claimant's not on Medicare, which makes sense, right? The person's not currently entitled, unless they have that reasonable expectation of being on Medicare and your workers' compensation settlement is very large, over $250,000. Okay. Those are workload thresholds. Those are not safe harbors. And that's the most important thing I could probably tell you. It's probably the thing that I see get screwed up the most, or the concern that I have the most. I think that this confusion is getting better over time, but it still crops up. I've heard attorneys say things to me like, hey, can we break this up into 2 or 3 settlements and we'll make the settlement just under the threshold? I'm like, no, that doesn't work. Okay, Greg, how about if we write down in the settlement, with the workers' compensation settlement, we write down that all of this is for lost wages. This is just $30,000, $40,000 to pay them back the lost wages. And this is not perm and this is not medical. First of all, I wouldn't let my client probably enter into a stupid Section 32 like that. But number 2 is you're clearly just trying to build the settlement in such a way that you're trying to pretend that medical is not part of it. That's not going to work either. Okay. So I would also say, if you think that opposing counsel is asking you to do something, that's a little question, this is the moments, right? Office hours are made for. This is the moment where we should, tap somebody on the shoulder and go, hey, this is weird. Why do you think this demand looks like this? Or why do you think their counter demand looks like that? Why did they say these things? Do you think I have a Medicare secondary payer issue? I would be asking someone. As of July 14th, 2025, and this is with the publication of the new reference guide, Medicare says we will no longer issue $0 set-aside proposals. This has never been my process. and first of all, my process and our best practice is we've never looked for pre-approvals, right? If a client wants a pre-approval of a set-aside arrangement, we support them, okay? We help them, but that's not something that we encourage. I don't see that there's a great value to it. But there was a practice, and some people have a practice of seeking $0 set-aside approvals. In other words, you're closing a controverted case where we've never paid anything, we denied it from the outset, you're going to settle it for $7,500, and then on top of that, go and get a $0 set-aside approval. Medicare used to do this. Actually, they wouldn't do it for $7,500. They do it, have to be over $25,000, right? They used to do this, used to issue these letters. They're no longer issuing these verification letters anymore. Now, we should be prepared to counsel our clients about the different levels of risk that they are taking on when they think about their set-aside arrangements and whether or not they're going to seek pre-approval of them or submission of those, okay? So we should know that if they are going to create a set-aside, that's going to be based on that reference guide method that I talked about earlier, which is going to take the person's life expectancy. It's going to take it and multiply it basically by all the medical they've received and come up with this big projection, a doctor bias projection. And then they're going to submit that to Medicare CMS, Center for Medicare Services, for that pre-approval of that set-aside arrangement. That's the lowest risk way of handling a workers' compensation claimant that you're going to do a Section 32 and that they have Medicare entitlement. Okay, that is as safe as it gets. Okay, that is belt and suspenders. Now, most of our clients at this point are, I want to submit for pre-approval where I can. So as long as they meet a review threshold, they want to submit for pre-approval. Our advice is, okay, if that's that's your preference, we'll support it. We'll help you. We'll put together anything you need. Usually grab vendors. Go ahead, Matt.
Do any of our clients actually use a doctor-based approach anymore?
Yeah, they do. Yeah. All right, so that's the lowest risk. They're likely to have the highest potential exposure. And then the downside, of course, is they could submit that proposed set-aside arrangement to Medicare. Medicare comes back and goes, oh, you want to put $100,000 in this set-aside? Really, you should put $600,000. What happens to your settlement? Probably blows up, right? And that's, we've seen that happen. And the types of things that cause our settlements to blow up are where there's a huge medical cost, huge medication cost, pain medications, and typically driving those. And so that it becomes inefficient, not financially viable for us to continue with that settlement in that way, okay? Second thing they can do, a little bit more risk, is they can choose to do an evidence-based set-aside, use a vendor. They're going to try to price it as carefully and efficiently as they possibly can. And then they can choose to submit or not submit. And again, their risk is going to sort of vary based on whether they submit or don't submit. Safest thing you can do, of course, is submit and have Medicare Center for Medicare Services bless that. Last thing they could do, not submit, right? And we're comfortable with this. Not submit, come up with a set-aside that's based on a legal opinion. It's fine. It's absolutely done. Now, there are really good firms out there that just do this, right? And, I tell my clients, I don't know why you wouldn't get just a legal opinion-based set-aside, because you're actually getting something better than you're getting with when you use a vendor and you do a repricement strategy. Because the lawyer somewhere has a legal malpractice policy. So if it gets determined later on that they underpriced it, you can sue them, right? That's pretty nice. So that's potential. Also, we'll do a legal opinion set-aside arrangement when it's a low-value case. When you're going to do a Section 32 for $20,000, and you're like, how much should we put in the set-aside? And what's a typical thing we'd come up with? Oh, we'll put $4,000 into it. We'll put $5,000 into it. Where are you coming up with that number? Well, your estimate, you're looking at it, but we're not using medical vendors or using consultants to come up with that. Again, that's a legal opinion, okay? And that's all possible. Now, in practice, if clients ask me, I generally advise them against getting pre-approval of set-asides. I think it just wastes time and there is a downside risk to it that Medicare can come back and say, you need to put a lot more money in the pot. However, I'm just going to keep saying that some clients like to do it. They have internal risk management guidelines that say, hey, we do this all the time. We care about safety and security. That's fine too, and we will support that. All right. Medicare approval. Our job, okay, our job is to look for what's slipping through the cracks. A lot of these cases, when they come in, the client's going to tell you the person's on Medicare, person's Social Security entitled, but we have to put our thinking caps on and we have to be proactive because things are going to change as your cases develop. Now, we've been a law firm since 2015. And we have very few cases that are still open from back then, but there are some, guys. And we do have some cases with a 2016, 2017, 2018, 2019 date of loss. I want you to think about that for a second. 2016, 2018, 2022 date of loss, right? That person got injured years and years and years ago. A lot has changed in their psychosocial context. They might be on Social Security disability at this point. They might be Medicare entitled. So just because when the case came in, they weren't Medicare entitled, they might be now. Okay, so this is something that we owe to our clients. We got to be looking for these things. In general, I'm not telling clients that we recommend getting Medicare approved ones, but again, I think you've heard from me say this over and over and again. If they want to, that's fine. Okay, that's fine. All right. Last thing, I'm gonna repeat this until everybody gets annoyed, which is review thresholds are not a safe harbor. Okay, just because you're settling a low value case, if the claimant is Medicare entitled, we absolutely have a Medicare obligation. Okay, and that is, and your opposing counsel says to you something like, "Oh, we don't have to worry about that. We're settling this for 10 grand." You absolutely do. Okay, that's not correct advice. This is the chief area where I think people get into trouble or start doing things they shouldn't be doing because of the ignorance or ignoring that on purpose, that aspect of the act. Last thing I'll say is we should not wait until the case is ready to settle, like the end, like we felt like we're already starting settlement negotiations, to start thinking about Social Security. We should be thinking about it in all of our cases. You have an older claimant, they're over the age of 60, they haven't worked for more than 2 years. Those are all potential Social Security entanglements. So you should be thinking about that much sooner than just the end of the case. All right, we have about 8 or 9 minutes left. Does anyone have any other questions about any aspect of Social Security at all? Anything. Could be case specific, just don't say the name of your case or client. Yes, you have an orange cube right in front of you.
What if there's a client that knows that the claimant's on Social Security, but it hasn't been 2 years, so they're not Medicare eligible, so they don't want to get an MSA because, they're scared of the medical, like we've already advised them, you should, but they don't want to. We did what we had to do and then negotiate settlement.
Yeah. So, and look, this happens, right? And I've actually had opposing counsel more frequently say this to me. Greg, my guy, right now we should settle this case because he's not entitled yet, but he's gonna be. Then I have to start thinking to myself, okay, what's my obligation to Medicare? Now, Medicare's already said, I need to, if I'm going to settle the comp case for over $250,000 and they're not entitled, I have to have my wheels turning thinking to myself, okay, I might still have to take Medicare's interest into account. But the way we would play that is, no, they're not yet entitled. It's below the review threshold and we think we can do it. So those are going to be very case by case and we have to be very thoughtful about that. And the last thing I'll tell you, this is client choice. If a client says to you like, hey, Greg, I don't care about that. We're going to go and settle this way. I would make sure I would save that email to the system, right? So yeah, okay. Because the statute of limitations on this is 5 years and, we're not going to remember any of these things. So I would keep that email. But again, this is about a future risk and this is all compliance work, right? Some clients, I think to themselves, hey, the chance of this getting matched are low. So I'm going to see what I'm going to do. Now, that's not our recommendation that they play that game, but that's up to them. All right, any other questions? All right, well, this is a fun topic. Let me walk you out. If you don't have our newsletter, you should get it. If you haven't listened to Christian's podcast, which I believe this month is going to be mock trial participants. All right, excellent. Okay, after the presentation, please on your way out the door, sign your way out. Those are at-home players. We are going to electronically take notice. Please rate me on this presentation. We have to turn in the ratings to the CLE Accreditation Board. So be kind. All right. Any questions about this? Come see me or any other partner. If you have any Medicare Secondary Payer, I love talking about this stuff. Thank you for your attention this afternoon. See you guys.